This faculty to get it's just like there's not a million people in the world who actually have sophisticated thoughts and expertise on this kind of situation. I mean, the frontier zones in particular, that's the part that's really interesting. And at a minimum, two countries. Oh yeah, we're gonna walk through the I would love to. That's great. Do you have time? Okay. Well, I would love to do that. Let's just see. But any of those things sounds great. I have my train is at 4, so it's something just do some stuff to like check out all that kind of stuff. But yeah, basically until like 3.
But I'm certainly
and if you need to leave sooner, then absolutely. This ends.
Guess what I'm trying to say? I think there might be a conventional assumption that you play it.
Oh,
when it comes to conflict. So I'm really maybe not at a high level of political leaders, but maybe like this. So how do we move beyond that? Without discounting.
That's good. No.
Yeah, one of those links to high school of 6 children and kid penalty. I mean, I know you were laughing. There's an internet I'm just so institutional.
Hey Tom, how are you? Long time no see.
I know.
Gradually moving back from Kent and out of the after my sister broke down.
Oh, how's she?
I get the sense of this.
There's a couple of ladies come in
Yeah, so you're living down in Portugal, right?
I was worried about publishing anything on Ukraine. Adrian Kemp, there was a lot of people said, go with it. So far,
Well, I'm not sure keeping your head down is the right phrase, but exactly so. Yeah.
It's a legitimacy. They probably could never have a build in the same way. It's really interesting. I'm just excited to be here and learn about this. The nuance of it is totally different from an American approach to the conflict on a local level and everything.
Could you just say though, if you think of the politics as American politics, but compare that to the US city where you go to local communities and the sort of thing that actually is happening on the ground in the sort of progress that we're into. There's a similar texture. Things that are awful as they are awful. You just got to coexist. And you're amazed at sort of work.
that's the best I can say. You're not going to be having mild meetings.
But it doesn't reach that.
There's still tells you something about society.
Well, I won't eat up your break.
You actually done Karen virtually this morning on Twitter. summers like this today.
I was busy. I was up there doing exactly.
On top of advocating for cycle infrastructure in Belfast,
Yes,
which is
which is my favourite campaign at the moment.
Dish the dirt.
Well, we should. I'd love to dish the dirt. I mean, if I can this dirt, it's very complicated around the role of even the one who was on mission. But it gets really. But it was the amount of time, the amount of stuff we had that got squeezed out on diversity staggered even me. How much that really stuff just squeezes things out. And you sort of think, surely we can see beyond this. So actually, a lot of the good bits and even reports sort of disguised. I found ways of writing stuff, along with David Robinson, who's a staff of writing things to disguise what I was writing on the basis that I hope they wouldn't notice what I'd said.
Yeah, so it's in their face. So when they start hitting those low tier government tier that's the word
Yeah.
world, you know, sensitive, offensive.
But I would welcome sitting down and chatting about that because I've almost got to, I've still got to get it off the Honestly, I think I did 900 hours of meetings. Yes, and there were paragraphs that went over and over. There were moments that there was once when Dave Robinson and I had written a sort of background history of why symbols and emblems are complicated thing, and we got very good reactions from Sinn Féin, and we got no sort of strong reactions from the Gooey People. Alright, we started to and then I got about halfway through the meeting I thought, because they then started arguing through the other hadn't read it. And now we're going through it. You're reading it for the first time, and all of a sudden the whole thing collapsed, and we have to go back and rewrite it. I got Tom Hartley actually rang me and said, you know, I need to get Northern Ireland in there a little, but not too much. You know, we've got it all structured and thought, oh my God. And Sinn Féin sort of went, look, we don't like it, but we can see that you haven't got over the top on it, so I'm going to make a comment about it. I thought it was deeply enriching. Right. It's so. Honestly, I mean, you have to hand it to Sinn Féin documents. They demand them 5 and 6 days before any meeting. They put people on them. They come back. Sometimes it's quite amusing because the people in the group are not the ones that have written them. So from time to time, you've got Tom Hartley couldn't quite write like what Sean Murray had written or something like that. If I'm to be frank. All right, but they put the work. None of the other parties put the work into that sort of stuff. You know, like Sinn Féin. And you've got to sort of admire that.
I wanted to pick up on what you said. I think it's actually an interesting point. And even in a loose sense,
yes, and I didn't really, I was put away, I wasn't thinking about it. resolve itself, give another 5 or 6 years.
It took, and it took me 2 commissions.
I didn't even, I knew
Decommissioned about it.
Yes,
Yes, 9/11 was supposed to have fallen into a bit of a hole around it, absolutely, because of American.
this is what it is. Yeah, that's right.
I'm not thinking about.
You could see that by using functional So if you take the other people, for example, ask them some questions.
What's the deal with it? And I was like, I don't know, like, not good.
When they are responding as per existing parts that like are parts that have a grammar and syntax of thinking, that is basically like ethics, it's right or wrong, it's good or bad. It's not about balance of power. Whenever you have the other kind of non-threatening situation, and I'm talking about existing, then people do well on balance of power.
So how much does that
It's very windy. I want to tell you, it's this windy.
Hi, and at the beginning, I was a bit naive on this. I felt it was really economic down. But then I worked out it was a natural flow that they had to do that. And if you waited long enough, sort of calms down. I was never quite sure if I was actually biological and that calming down. And then, often after that, you got some reasonable, maybe over a cup of coffee.
Like stranded cars.
I guess there are other talks
New York,
you
so
know,
it gets up to here and you go on the subway.
I think
It's awful.
is that in a curious way, the fight becomes the formation of the relationship.
yes.
And the more
It's like 2 hours of stress.
I'm looking forward to it. Maybe I need to get some.
okay, that's kind of
I didn't want to bring this.
it's
They are met Tom, actually.
No, I've always just thrown up. I'm different sides of it. Schedule, waterproof. These are serious. I was going to bring those on the plane. 10 pounds by themselves.
I think
It's my jacket.
the answer is we don't know.
Right, it's that
Experimental work.
Bengals
And
and
the experimental work is
England.
people whose whole cognitive sense is that of existential. And it's cost-benefit analysis. It's not utterly connected self, and they're not going to be influenced by some argument. So,
I mean, I do think, I've read some of the devoted economics, and I do think it's really interesting.
well, the thing that's been interesting, we've been working on this with Scott African, so
Yeah, no,
and it became very interesting. Was, because at the start I was quite skeptical of the Edinburgh because it was taxed, and I think it was the more we've done it, the more there seems to be coming through. This is how transform has functions, and the implications of The other thing I told us.
Colleague Louisa, by the way.
And how I much it was. No, and I think with John Hume, we get that phrase. I know what you
No, I actually think it's right until, it's a very
I understand why you get, who doesn't get frustrated, and that's not what's working.
resubmitted, take a reference to it.
I'm curious about
Now, it also said trust,
levels of government, but how do that conflict so trust is a political tool, particularly policy.
No, but I think that would be.
Of course, my national connection is also when you travel abroad to study,
rather than think of a single process,
I don't know what is it about.
or if it's a single process with friends, I think that again, from the experience, it seems to me really on this model.
So I'll see how that happens. Well, then,
Is that all right? I realise, you know, when you say things, I realise when I made that comment about not fit for purpose, I'd opened a box that I didn't.
No, the issue in this case is actually there's a lot of very similar chapters.
right.
And so it looks like you're feeding into that narrative.
Yeah.
Yes, yes. I sort of know that chapter's going on. I sort of felt it, and then the minute I said, yeah, but I don't. I'm not out to
That's why I didn't go for it.
Yeah, absolutely. Just not talking about
What's the book that, this idea of frontier zones, which is the book? Frank Wright, W.R.I.
Yeah, it's one of the first things I ever read. I never knew it.
he was 44 when he died. I was 28.
No, it resonates as soon as that expression.
I went to visit him because he went to his treatment, and it's actually quite
It sounds good. It wasn't that much that part, I guess. It's just the idea of frontier zones where that are messy precisely because being a frontier zone, things are blended and find levels of accommodation or homogeneous or whatever. Precisely. Well, with the borders, but where the borders, When you said it so well yesterday, I mean, taking the comfort zone. That's it. And also Holding states encourage and incentivize from most all the things that God says you can always help. Just like this again, it's all lies are lies. Encourage and help make it easier for somebody to and this area is particular. Yeah, no, it's a very good line. It's a very good line. So, some of the wild
So we're out in 5 minutes.
And if you could say something,
I'll leave that cup with you.
is that okay? Yeah, just say something really controversial and abusive at the start, and we'll take it from there.
Yeah, I know.
She's not on.
She comes on promptly.
Okay, so what I'll do is I'll leave it another 30 seconds then start, and I'll introduce her hoping she'll join us, but if she can't then once then. Okay.
Are they controlling mics from the back?
And the mics. So welcome back. It's great to get a chance to chair what I'm sure will be another invigorating session. The examination question we've been set for this session is legal and institutional achievements and challenges at the domestic and international level, Northern Ireland Lessons for the Peace Treaty Initiative. Again, we have a superb panel. I'm briefly going to introduce our three panellists, And then, as in the first session, we'll have a series of questions initially from me to the panelists to raise some of the issues, and then we'll throw it open to the audience for further questions and discussion, and look forward to that. Dr. John Topping is Senior Lecturer in Criminology here at Queen's University Belfast in the School of Social Sciences, Education and Social Work, and is a leading expert on research relating to policing, both in terms of the academic research that Dr. Topping does and also in terms of the socially influential impact that that work has. He looks at police reform, at public order policing, at stop and search powers, and at community policing in particular. Professor Christopher McCrudden is Professor of Human Rights and Equality Law here at Queen's University Belfast, and a leading expert on human rights and indeed on human dignity, a shelf of very influential publications. Normally when I'm chairing things I introduce my own work, but I'm going to recommend a book by my colleague, Professor McCrudden's 2018 OUP book, Litigating Religions, an essay on human rights, courts and beliefs. Litigating Religions, an essay on human rights, courts and beliefs, is a book of monumental importance, actually, on a variety of issues, including some of the issues we raised in the previous session when you're looking at competing rights and the questions of equalities when they clash. We're joined online, sadly not in person, but online, by Mariana Casipena, who is joining us and I think will be able to hear us. You can hear us okay, Mariana? So will be joining us. Sad that you're not with us in Belfast. Mariana is an associate at the Institute for Integrated Transitions, where she advises primarily in areas of transitional justice and victims' rights, and manages IFIT's Law and Peace Practice Group. Prior to joining IFIT, Mariana worked as a consultant for the Presidential Advisor for Human Rights in Colombia, and as a legal advisor for the Victims Unit during the negotiations between the Colombian government and the FARC. A fantastic panel. I'm going to start with questions to each of them and we'll begin the discussion that way. John, a question to a criminologist. Can I ask you about how important in the implementation of the 1998 Good Friday Agreement criminal justice reform was, and in your expert view, what might be some of the lessons or implications or intuitions of that experience for wider patterns of conflict resolution and post-conflict societies?
Thanks, Richard. A very, very broad question in 5 minutes. I suppose just for myself, I will hopefully bring today, just to this brief overview, a very practical perspective, somebody who has sat on the board and been chairperson of Community Restorative Justice Ireland for the best part of 11 years, somebody who sits on the Committee on the Administration of Justice's Board, somebody who's been an independent member of the Belfast Policing Community Safety Partnership. So hopefully a few of those things we can tease out a little bit more, as well as my own academic background. I mean, and obviously in the 5 or so minutes I have, you know, the police and criminal justice reform here has been described, I think, in various forms as nothing short of remarkable, one of the grandest experiments, one of the grandest blueprints of police reform ever attempted in Western criminal justice jurisdictions. I always like when talking about these, talking at these sorts of events, to go back to David Bailey, one of the former oversight commissioners who sadly passed away a couple of years ago. And he always said this about the police reform and the criminal justice reform process in Northern Ireland. He said that essentially that there's two ways to look at it. One very positive view, that on one hand it's absolutely fantastic what has been achieved here in terms of the sheer scale of reform, the absolute fundamental, in some cases, redrawing of the boundaries around the policing, particularly the policing institutions, and all the benefits which have come with that. As a criminologist, we live in one of the safest countries in Europe, at least according to official crime figures. We have a decreasing threat level, and it's a relatively, as we like to tell our students as well, it's a relatively safe place to live and work. But the other side of that coin from David Bailey is this, is that he said, as well as that optimism, probably some healthy element of pessimism as well, in terms of what it took to achieve that which we did in terms of social, political and financial capital for such quite a small jurisdiction, you know, from you know, the global interest that we've had. If it took that for such a small entity, what hope, he said, are there for other jurisdictions, larger jurisdictions around the world trying to achieve similar aims and outcomes? In a couple of minutes that I have, I mean, I'm certainly not going to go into any of the detail of criminal justice reforms, and obviously policing is my area, but I think, you know, very much we can look at the broader criminal justice reforms in two sort of key, broad, very bird's eye view strands. One was very much about, you know, beyond the technical processes, about resetting, redrawing the boundaries of inclusion and exclusion around policing, about ownership of what policing and security actually means, about the standards that we want in terms of human rights, about the levels of accountability, about demilitarization, and the composition of the justice system that we had, and that was a long, technical, difficult process, as we all know in this room, both financially, both politically, and I suppose always great to have a degree in hindsight, you know, looking back to where we are, you know, looking back to what we've achieved. As I've already said, a lot has been achieved, but as part of that, I suppose, two-part answer, while I think the technical frameworks and the structural frameworks that were put in place got us so far, I think any peace process and any reform of the criminal justice system, in terms of the live experiment, the practical experiment that we've had in that Northern Ireland, is the sheer longevity of how long these sorts of processes take. The Patten Commission never envisaged that we would have many of the problems that we still have here today, in terms of the security threat, albeit diminished, in terms of issues around composition, for example. We still have not cracked, you know, the balance of PSNI and who they represent. You know, George Hamilton, former Chief Constable, made that very clear as he departed there a couple of years ago. And we also have, you know, the changing landscape, I think, beyond security. I think Patten, the criminal justice system, was very much focused on getting us from A to B in terms of getting those processes in place. But again, as Northern Ireland becomes more progressive, we've faced issues which are resonant in many other countries, many other jurisdictions around Black Lives Matter. We're looking at what sort of standards, human rights and others, do we actually uphold? How do we do normal policing in an abnormal, you know, I suppose in an abnormal environment? And I think, you know, just I'm just throwing a few things out here and to get some thoughts going maybe. I think, again, taking a step back, that the broader criminal justice reform here, it's always healthy to keep an eye on the ground. We can have all the grand systems, all the grand oversight mechanisms, accountability frameworks, etc. in place. But what does that mean, and what does that mean for ordinary people and communities on the ground? One of the missing parts for me, the criminal justice process and reform process, was an educational element. You know, telling communities, what does this new thing that we have, what does it mean for you, me, communities in society? What is policing in 21st century, you know, what is policing in 21st century society? And also thinking, I suppose, more broadly, and just to finish, I suppose the issue as well around maintenance of standards. I think it wouldn't be unfair to say that we have perhaps seen a slide in human rights standards in terms of what PSNI are delivering in the ground, raising questions about the role of the policing board, once sacrosanct. You know, what are they actually doing in 2022 for working class loyalist and Republican communities, loyalist and Republican communities? Keeping a healthy eye on that. How do PSNI interface with new communities vis-a-vis the Black Lives Matter protests and the disaster that was for them back, you know, a couple of years ago, and also the poisonous effects of legacy on the delivery of everyday policing. So on one hand, a lot has been achieved. On the other hand, I think you know, the broader criminal justice reform process only was ever to get us so far, and to some extent, PSNI and the criminal justice system has been left to mop up the unfinished business of politics, something which I think they didn't envisage they want, probably a place they don't want to be either. So just a few things out there to get us going. But Richard, I'll pause there.
Thank you very much indeed, John. Chris McCrudden, turning to you, looking at the field of human rights, could you say something, Chris, about the ways in which, or the degree to which, international legal standards have or have not informed and advanced the peace process in Northern Ireland?
So, first of all, thank you for inviting me. It's been really very stimulating. If I may, I'll take the question in two parts. So, one part is, as it were, the issue of the importance of international law generally, and then more specifically the role of human rights standards of international law. So, taking the first issue then, what's the role of international law generally in the peace process? The form of the Good Friday Agreement was, at least partly, particularly the agreement between the UK and Ireland, was in the form of an international treaty. And that wasn't accidental. So it was formally registered at the United Nations, for example, by Ireland. So the legal form, as I understand it, there are others in the room better qualified than I am to interpret the past, but the legal form was intended, as I understand it, to signal its formality and its importance. Most particularly to the political parties that were participating in the parallel negotiations. However, although the form of an international treaty was adopted, there was sufficient trust, coming back to the point I made earlier on, there was sufficient trust between the two governments at the time that it wasn't considered necessary to have the usual mechanisms of compliance, interpretation, and enforcement at the international level. So, indeed, Ireland had already taken steps to prevent the International Court of Justice having any jurisdiction over any issues to do with Northern Ireland. That was from Ireland. So, in short, the legal form was important, largely for expressive purposes, but the implementation was to take place through domestic legislation, north and south, but only partially. So only part of the agreement was brought into domestic law, north and south. And the second element was supposed to be political. So it was a political mechanism for implementation and enforcement. So the north-south bodies and so on. So between 1998 and 2016, and I choose 2016 advisedly, primarily political resolution was in play, with occasional resort to the courts to enforce the domestic implementation. But that was only occasional. But in terms of international law, since 2016 and the Brexit referendum, all that's changed. Trust between the UK and the Irish government has broken down. The lack of effective mechanisms for implementation and enforcement of the Good Friday Agreement have now become apparent. And it's unlikely that any future agreement, and this is partly the question I was asking Dominic earlier on, that any future agreement that might replace the Good Friday Agreement, which I must say I wouldn't advocate at the moment, any future agreement will not carry any credibility without greater legal status at the international level. So the idea that you can get away, as it were now, with a treaty form, but essentially only political implementation, that's for the birds. Unfortunately. So the legal status of the Good Friday Agreement has now become, of course, immensely political and immensely important because it's part now of a narrative which accuses the UK of acting contrary to international law in a series of other situations. So the problem with the Good Friday Agreement not being implemented now legally is part of this larger narrative of non-compliance by the UK. And the very length of the protocol, the Ireland-Northern Ireland Protocol, and the care with which it was made enforceable shows the extent to which international legal mechanisms have now been drawn on explicitly rather than informal trust-based methods. Indeed, the protocol in several ways makes aspects of the Good Friday Agreement legally enforceable in ways that the original Good Friday Agreement did not, and now effectively makes the EU co-guarantors of the Good Friday Agreement. Okay, so second part of the question then is, how have international human rights legal standards helped to inform and advance the Northern Ireland peace process. So in this context, I'm assuming that human rights encompasses both human rights traditionally conceived, that is, primarily directed at state actors, and equality and non-discrimination requirements, which are directed at both state and non-state actors, such as employers, service providers, and so on. So this is a human rights plus mechanism that we're talking about. The simplest way of answering the question, which of course, you know, as you said, with regard to yours, is immensely complicated and basically requires a lot more to do it justice, is to point to, bear with me, 5 particular ways in which these international human rights and equality standards played a role in the peace process, okay? Sorry, it is complicated. First, in the lead up, in the long lead up to the Good Friday negotiations, the question of whether Northern Ireland was reformable and therefore whether the armed struggle could be parked while negotiations took place, leading to an agreed and reformed Northern Ireland, that question of whether Northern Ireland was reformable was a central issue among nationalists and especially Republicans. And one of the key tests of whether Northern Ireland was reformable was whether the history of discrimination that was mentioned earlier on, particularly in the economic field, employment, housing, against Catholics and nationalists, we should name the problem, could be eradicated. Because if it couldn't, then Northern Ireland was not reformable, and the armed struggle would continue. And not just discrimination, but also structural disadvantages which Catholics suffered, particularly in higher unemployment, whether they could be reduced. So the relative success of legal initiatives to tackle those issues gave some confidence that Northern Ireland might just be reformable. Of course, that can be reversed. So second, the European Convention on Human Rights had been a central forum in which complaints of state abuse were regularly aired from, increasingly from the collapse in public order, the introduction of the British Army, resulting armed conflict. So it was, as a result, inconceivable that the European Convention on Human Rights would not become a central element in any future peace agreement. Inconceivable. And this was recognized, I think, fairly early on. It was a happy coincidence, but it was a coincidence, that a new Labour government came into power the year before the final push in the negotiations, committed in any event to the introduction of the Human Rights Act across the UK, which the Good Friday Agreement could then piggyback on. But that would have happened anyway. Third, beyond these specifics, human rights standards provided some basis for arguing that there were values and principles that were common to both loyalism and republicanism, and thus provided some common ground. This is particularly so in the context of the all-important Downing Street Declaration negotiations, which I think are underplayed in many of these discussions, which of course predated the Good Friday Agreement and in many ways anticipated the Good Friday Agreement. The fact that elements of the PUP, the Progressive Unionist Party, proposed human rights language to the Irish government, which was accepted by the Irish side and included in the text of the Downing Street Declaration, established a degree of trust between the two sides that they could cooperate. Fourth, political unionism, as opposed to loyalism, and everyone in the room will understand what I mean, was noticeably cooler towards equality and human rights standards being incorporated in the Good Friday Agreement. They didn't oppose them, however. In only one respect, I think, did the Ulster Unionist Party actively support the introduction of human rights standards. As I say, they didn't oppose, as far as I am aware, but they didn't massively support them either in terms of their agenda, except in one respect. And that was with regard to the Council of Europe's Framework Convention on National Minorities. And one in particular of, and people will know exactly who I mean, one in particular of the Ulster Unionist Party negotiators developed an argument that acceptance of the Framework Convention on National Minorities would safeguard the Protestant Unionist community. Fifth, lastly, you'll be glad to hear, the threat to the EU underpinnings of some of those human rights and equality guarantees by Brexit has, of course, now led to significant pressure on the negotiators in the withdrawal negotiations to include guarantees of non-diminution in the EU-UK withdrawal agreement in the protocol. And this was included in Article 2, of course, of the agreement, which refers specifically to the human rights and equality protections in the Good Friday Agreement, underpinned by international law. So we come then to a situation where originally it looks like international law is providing a relatively expressionist, as it were, role, rather than a formal implementation role. That was true to some extent. That is now completely changed. Generally with regard to the peace agreement, but also specifically with regard to the human rights agreements. Thanks.
Chris, thank you very much indeed. An enormous amount there too, and very rich insights. Mariana, I'm going to turn to you now. I want to ask you a question specifically, if I may, about the Peace Treaty Initiative. But it builds in some ways or follows on from Chris's second point there. And I want to ask you about the ways in which the Peace Treaty Initiative might be able to balance two seemingly potentially centrifugal elements. I mean, one is the question of international human rights standards, the rule of law standards, which are global and transferable. But the other is the very specific aspects of particular conflict settings, in that while conflicts might have resemblances between them, each of them in some ways is also unique. Can you say something about how the Peace Treaty Initiative, Mariana, is trying to balance those international standards of law with the flexibility that might be required? Mark was mentioning earlier on, talking about Afghanistan, talking about Libya, talking about different specific settings, which are very different, with the flexibility that might be required with peace agreements in particular circumstances.
Thank you, Richard. Thank you for the invitation and for helping us organizing such interesting events and conversations. I would like to start, if it's okay with you, first noting that the aim of the peace treaty is to contribute. We are aware that international law cannot solve everything. It cannot solve every single problem that negotiations encounter. But it is our belief, and we're convinced that international law can and should be at least helpful for preventing and for resolving conflicts through peaceful means. And in this sense, what we're aiming to create is a framework that helps, that gives incentives, that helps fixing some of the elements and some of the barriers that we might encounter. And the question that you're asking is actually a very good example of the barriers that are encountered in negotiations and how we believe international law can contribute. As we all know, negotiations are very hard to mount. And they have intrinsic needs and intrinsic constraints and limitations. And for example, negotiations might necessarily imply mutual concessions and difficult compromises and difficult choices. And this happens because if you're sitting down and you're negotiating, it is because none of the sides could impose its will on the other one. It couldn't impose its will on the other party. And therefore, in remembering that we are in a negotiation, that it might imply difficult choices, we need to remember what we're aiming for. We're aiming to prevent and to resolve violence. We're aiming at preventing atrocities. And this often obliges us, therefore, to balance very fundamental principles and values. It obliges us to balance, for example, punishment and prevention. It might oblige us to think about balancing what is desirable with what is actually possible. This, every single time, every context is different, but every single time, negotiators and mediators are pushed to be creative in terms of alternatives, in terms of formulas, and in terms of sequencing, to think about what is possible, how can I achieve peace, how can I prevent further violence, how can I prevent further atrocities, but at the same time, address the past and look and build a better future. So what this international, what we're aiming at doing actually through the Peace Treaty Initiative is to making negotiations more organized and attractive and accessible. This is the reason why we're aiming at proposing an incentive-driven treaty. And this treaty, this is something that we will address in the next question, I understand, Richard, but if I may touch upon this now, it has to do with how do we increase flexibility and how do we ensure greater legal clarity on key questions, on very hard questions and difficult choices that have to be made of international law that negotiators we know are encountering almost systematically in the different processes. And so one of the examples that I would like to share with you is the presumption of conformity that we have included in the draft of this peace treaty or multilateral treaty for peace negotiations. The presumption of conformity actually speaks to the outcome of a negotiation, its protocols and different undertakings, and it speaks about the presumption of conformity of this outcome of a reached accord with international law. This is something that is very new. It would be an innovation in international law because it doesn't exist as of now. Today, it doesn't exist in international law, but it is a figure or an element, a tool that we have identified in several constitutional law branches in different countries. What it aims at doing is at ensuring that if parties in a negotiation follow the minimum standards created by laws of peace negotiation, then they will have greater certainty that this agreement will have legal certainty, that this agreement will have legal clarity, and increase, therefore, the chances for implementation. But as being a presumption, it can be rebutted. So our aim is not to say whatever you decide, whatever you agree, it will be crystallized. Nobody can touch it. This is not our aim. And as a presumption of conformity, and particularly regarding to atrocity crimes, the presumption of conformity shall not apply if the states parties of the convention that we're proposing find that, for example, what was written in the accord is excessive and unnecessary to achieve the prevention of the resolving of the conflict, and if they find that what was agreed actually neglects to incorporate targeted measures addressing victims' rights, for example, that it neglects to include the search of the missing or of the disappeared persons. This is an element that we aimed at including for two aims. One, to protect flexibility, because today there is no a standard that is included in international law that speaks to the different kind of tools and elements that have to be taken into account in a situation of a window of opportunity of achieving peace. But also to acknowledge the fact that today we have huge developments and advances with regards to victims' rights, with regards to human rights that need to be fulfilled and that need to be followed for a peace agreement to be sustainable and for a peace agreement to finally achieve what it aims to achieve, which is peace and preventing further atrocities. So I would leave it there for now. I know it's a topic that can go a long way, but I would leave it there for now if it's okay.
Thank you very much indeed, Mariana. That was really, really valuable. John, a second question for you. Internationally, a lot of attention now in peace building is focused on the idea of peace building needing to be an inclusive process of bringing various communities with us. Can you say something of your judgment about, in the Northern Ireland context, the implementation of the Belfast Good Friday Agreement? In terms of criminal justice reform, how far has there been a success in gaining community engagement?
Yeah, another broad one, Richard. I suppose in terms of it's always easier to concentrate upon the police as the front edge of the state in terms of the criminal justice system, the entry gateway for a lot of people, and I suppose it goes back to the CAJ, their seminal conference around police reform. I think it was back in 1999, and he's now passed away, Maurice Hayes, at the time, talked about community policing or policing with the community in the terms of Patten Report, Patten Recommendation 44, that the core function of the entire service should be geared to doing this thing called community policing or policing with the community. And what we've seen over the years is community policing has taken many different forms. It's been reinvented by many different chief constables in lots of different ways and called different things, but fundamentally it is the same thing. It's about engagement with communities. But in terms of sort of my own sort of assessment and perspective, over the years, I think sometimes it does us no harm in our complex society. I'm always a fan of doing the simple well. And I always talk to students and different people about this. And policing works best where it's needed least. That is the fundamental rule, I think, doesn't matter Northern Ireland, across the globe. So when you actually drill that down into Northern Ireland, I always see some of the criminal justice reforms and the police reforms here, as I describe it, as both as a glass floor and a glass ceiling. So on one hand, it's a bit of the police reforms here and this idea of engaging with PSNI, and the PSNI being from and of the people and representing communities. A bit of a glass floor insofar as there's a very significant majority in society who look down through this glass floor and are glad things aren't as bad as they were in the past. That things have changed fundamentally better. We live in a relatively safe society. But on the other hand, that glass floor also acts as a very significant glass ceiling for many working class, loyalist and Republican communities and other communities in Northern Ireland who have never quite been given or have attained the policing which they were promised as part of the police reform, as part of the criminal justice reforms here. And when you go back to it, we of course have, this brings into question the role of, I think as I mentioned before, the Northern Ireland Policing Board. And every year they produce their fantastic annual survey, and confidence in PSNI has never been higher. But if I'm to ask anybody in this room, what is confidence and satisfaction of the police really like at a local level, below a district level in the criminal justice system in PSNI? The answer is we actually don't really know, because nobody's ever properly measured it. Apart from the occasional Northern Ireland Life and Time survey, the Young Life and Time survey, apart from occasional reports and bits of research which I've been involved in, I think, I've always said to the policing board, what is the price of not knowing at a granular level what people really think of policing? And that has always been a missing trick. What do we understand about the Craigan or the Bog side of the Shankill or the Falls? Well, when we don't produce much fine-grained data about this, how on earth do we really know? So for me, the pulse, the only place we have to go, and the pulse of sentiment around policing and criminal justice system has in fact for me rested with the voluntary and the community and the NGO sector. If you go back to the Criminal Justice Review of 2000, aside from the Patten Report, it very much redrew the boundaries of criminal justice, and it was all about the police, it was all about the criminal justice system, to the exclusion of much of the vibrant voluntary community sector, which throughout the conflict had played an extraordinarily important role in upholding the social capital community fabric in Northern Ireland, and still to this day actually do. And it's been a very long process in accepting that, even if we come up to sort of the criminal justice inspections of 2006, 7, 8, around the community-based restorative justice schemes here. It took 10 years for the penny to drop that we actually need some of these schemes on board, because they are representative of the community. Otherwise, we just have communities of individuals. And it's no coincidence that the conflict, as we know, affected people mostly from working class communities within a radius of some of the peace divides here. And it is those groups who provide the gateway for engagement. And also as well in terms of this watching brief, I suppose, the NGO sector, some of the community sector NGO, particularly the likes of the Committee and the Administration of Justice, providing additional levels of community-focused accountability above and beyond the very grand police metrics, which mean very little to people on the ground, and particularly through our various, what were the DPPs and now the policing and community safety partnerships. And the other thing I would say on community engagement and this idea of engaging communities is this, 20 years on from the PSNI coming in to existence, if you were to ask somebody in the street, what does community policing really mean? You'd probably struggle to get an answer out of them in some of those harder to reach areas, and we're still having debates. Not so much. It's a bit like that difference between the positive piece. Is it just the absence of violence? I think sometimes we're still glad we're still having debates around, well, how many IEPs have been fired? What are the levels of stop and search? Levels of paramilitarism. When we're still framing police engagement in those terms, it's not a very healthy place, and I think we are still missing a trick going forward as we move, and I'm certainly not an advocate for or against sort of the whole, defund the police, defunding of the police movement, but I think we are still stuck in a community policing framework which defined policing here 20 years ago. Around engaging with particular communities in particular ways, but we do, I think, have the opportunity for much more intelligent and clever ways, because of course we're in a new era where we're talking about a much greater diversity in Northern Ireland. We are also talking about and the potential to include ACEs, the adverse childhood experiences. We're also dealing with waves of mental health, yet in Northern Ireland we're still stuck on policing about sort of bobbies and the beat type stuff, which was bound up in Patent Recommendation 44. So I think it's something we haven't gotten right. Various chief constables have tried to do that, again going back to the idea of policing works best where it's needed least, and I think there are many communities who are still struggling to get a sense of normalised policing, of everyday policing. Again, it goes back to that educational element I talked about in the first question, and I think that has been a big struggle. And how do you do policing in an abnormal environment? It's easier in some of the softer, more middle class type areas, but in those more difficult areas, I think there's still an awful long way to go. And regardless of what some of the wider social surveys tell us, the lived reality on the ground tells us that it is still extraordinarily different to get policing right. So I think until we can perhaps move away from some of the security debates, and we do have a shift away from paramilitarism, and we do actually appreciate much more fully the voluntary and community sector, because I think when you talk about the successes of community policing, PSNI, I'll quite happily say, yes, aren't we great? The crime figures are the lowest on record in our last 10 years. Well, actually, what about the role of the voluntary community sector? They have been playing in some of those upstream preventative problem-solving processes, which have always existed for the last 30 or 40 years through them anyway, in the absence of the police. So that's, I think, a nettle to be grasped, because we are quickly, with funding and so on, we are quickly losing a lot of the voluntary and community sector. They're petering away, that knowledge and experience is drifting away. And then, of course, what are we left with? We don't want to be in a position where we end up policing communities of individuals. There's an opportunity to grasp pre-made, highly evolved, highly intelligent, highly developed social community networks. And I think if we don't do that, then we're perhaps back to the situation where we have in, no different from Manchester or London, where it's just a community policing and community engagement becomes that constant uphill struggle, and it's a very hard circle to square. So just a brief assessment there, Richard.
Thank you very much indeed, John. Chris, you're a professor of human rights and equality law. Human rights and equality issues were addressed in the Belfast Good Friday Agreement of 1998, but some of the aspects of what the peace process promised, probably most famously a Bill of Rights, are yet to be implemented. Could you comment in your expert view on the degree to which the non-implementation or the non-realisation of some of those elements relating to human rights and equality have provided a real obstacle or problem or crisis even for the peace process? Sure.
Just one comment on what John has said. I think we should recognise explicitly the role that Chris Patten played in all of this. I think his role is both immensely important, but also something that we should be constantly thanking him for in terms of his commitment and his intelligence in dealing with the issues. And just on the composition of the PSNI, you said in your first comment that the composition issue has not been fully dealt with. Well, in part it hasn't been fully dealt with because the UK government did not renew the quota arrangements under pressure from the DUP. So, you know, we need to be careful that we don't do own goals here in the short term. So turning to the Bill of Rights issue, so the question is, does a lack of progress on the Bill of Rights pose a challenge to the stability of the outworkings of the Good Friday Agreement? And I think the answer is both yes and no. So I should begin by saying, particularly because I'm going to say something controversial in a minute, I should begin by saying that I support the enactment of a Northern Ireland specific Bill of Rights. And I believe that the protections for human rights and equality were of fundamental importance in securing the peace and in securing agreement in the Good Friday Agreement. So I take that as read for the moment. In itself, however, here's the controversial bit, I do not believe that the absence of a Northern Ireland specific Bill of Rights posed a challenge to the stability of the peace in itself until recently. So that was largely because there was such a panoply of other protections in place: domestic equality legislation, EU protections in the Charter of Fundamental Rights and Equality Law, the ECHR, the Human Rights Act, access to the UN supervisory bodies, etc., etc. There was a huge panoply of human rights protections put in place. So in itself,
It's a test.
oh, well, I assumed
Controversy alarm.
it was an objection to what I was saying here.
Don't say anything controversial, Professor.
No. So in other words, there were alternative remedies and forums available, at least to some degree. And I have to say also, and you know, my human rights friends are going to start then kicking up about this, there was also a problem in the kind of all singing, all dancing versions that were proposed. So there was a kind of inflation element going on here. And there was also an attempt to use the Bill of Rights to unpick some aspects of the consociational elements in other parts of the agreement. Right? So that tension was never fully resolved. That's then. Now we're in a different place. So with the significant ideological shift that, I'm sorry, Brexit both resulted from and to a degree caused, the consensus that a rule-based European and international legal order could be relied on and to a degree enforced at the domestic level, that's now disappeared. So a whole raft of legislation has already taken away or threatens to take away several of the underpinnings that made a Northern Ireland specific Bill of Rights less pressing. So in other words, if you remove the underpinnings of all the other bits, then the Bill of Rights is going to come much more into central focus. So in the absence of these other remedies and forums, the absence of a Northern Ireland specific Bill of Rights now does become a threat to the stability of the peace, but only because it's a peace with the other underminings. So rather than, you know, the problem being, which is sort of the implication of the question, rather than the problem being lack of advance in human rights protections, now you're seeing the undermining of existing protections in a significant way. And you know, it'll be interesting to see what the House of Lords does on precisely that question when we get into committee stage in the protocol bill, because Article 2 is obviously significant here. So no pressure, John. So not surprisingly then, the threatened repeal, now fortunately shelved at least for the moment, of the Human Rights Act, the retained EU repeal bill, and the Northern Ireland Protocol Bill, all taken together, have all focused attention, therefore, on how far a Northern Ireland-specific Bill of Rights might now play a role in replacing the gutting of the other protections. And the answer is, thus far, unclear, because the tentative moves towards tackling the issue in the agreement that restored Stormont last time has now disappeared. Right? So there was slight progress with regard to the Bill of Rights, at least being talked about in a serious way, with the setting up of the ad hoc committee in the Assembly. It looked like there was a possibility that there might be an agreement in principle, that there would be further talks about a Bill of Rights, and now that's gone, because the DEP pulled the plug even on the agreement in principle that the other parties were willing to sign up to in the ad hoc Assembly Committee's report. So, in short, I don't think it was undermining the peace process up till 2016. With the dismantling of the other protections, the Bill of Rights now becomes a much more pressing issue. How far it can actually tackle, however, the undermining of those other mechanisms remains to be seen, but the relatively recent Supreme Court decision about Scotland and their use of international law and the extent to which the Supreme Court has now challenged that leads me to be slightly more skeptical about how far it can actually fill the gap that's going to be left by the gutting of the other provisions.
Chris, thank you very much. Mariana, another question for you, and then we'll move to questions from the audience and from the floor. The Good Friday Agreement is often referred to as involving something of a constructive ambiguity in the way it tried to resolve certain issues. Again, a question for you about the Peace Treaty Initiative. Could you say something about the role of constructive ambiguity in how you and colleagues are envisaging the Peace Treaty Initiative, and in particular the way that it might ensure the sustenance and enduring strength of peace agreements in particular contexts?
Thank you, Richard. So this is actually a very interesting question for me, because as a Colombian, and as you might know, in Colombia, we had the opposite of a general framework agreement. We had a very detailed, more than 300 pages long peace accord that included a huge amount of details. So I tend to think more about that kind of peace agreements when projecting and working on the Peace Treaty Initiative. And one thing that we managed to learn during these few days of conversations and what
We've temporarily lost Mariana.
in fact, constructive ambiguities are also present in the Colombian peace agreement, even with the huge amount of detail. Hello, can you hear me?
So we temporarily lost you there. So if you could just go back a few sentences and repeat that, if you wouldn't mind, just so we can make sure that we had that. Your initial statement is okay about the detailed document, but if you could go from there, sorry.
Okay. Thank you, no problem. But even though we have a very long document, the Colombian peace agreement also includes very important constructive ambiguities that allow the parties to not have to agree on very contentious elements and postpone that conversation to other processes, perhaps even within the democratic institutions when the implementation phase would start, right? What I do think that is relevant for both the Colombian and the 1998 agreement with regards to constructive ambiguities is that the Peace Treaty Initiative, what it aims to do actually is to highlight the importance of flexibility in peace negotiations and to protect that necessary space of flexibility that negotiations require. Some people might say, and this is actually a natural immediate reaction, codifying, something would remove flexibility, so that it would be dangerous to aim at creating international law for peace negotiations, because that would mean that you are codifying processes that are so highly unique in every single context. What we have identified, and this has to do with the role of perhaps some national or regional or international bodies and courts. But what we actually aim to do is to ensure that as we have rules for peace, we have human rights. As we have rules that are very specific to war, we have rules of war because we're aware that we cannot apply the same rules as we apply during peace when we're at war. We have specific laws for that. We need to have specific laws for this particular window of opportunity that is so unique, so fragile, and so hard to mount as negotiations, so as to protect and to ensure that there is a margin of maneuver and that we reduce the levels of anxiety that negotiators have, because they don't know how far they can go, how far is acceptable, how far is not acceptable. And so as to also increase the legal certainty of peace agreements, because at the very least you cannot solve everything. I do not get tired of repeating this, because we know that we will not be solving every single problem, but you reduce the risk of having a peace accord that might afterwards be considered as an illegitimate or an illegal peace accord under the human rights standards, for example. This has a little bit to do with what Professor McCrudden was mentioning in relation to the jurisdiction of the International Criminal Court or the International Court of Justice. In our case, for example, today as we speak, the transitional justice system of Colombia is being studied by the Inter-American Court of Human Rights. And it is being studied under the view, under the eyes, under the legal tools of human rights. So there is, of course, precedent, because Latin America is a region with a lot of experience with regards to conflict, peace, negotiations, and amnesties. But the legal standards that are at hand are only the ones on human rights and only the ones with relation to war. So what we aim to do, again, by saying, and with this I close and I get it back to you, Richard, is that the absence of legal standards are actually reducing flexibility and exposing or making it more difficult to be able to negotiate better peace agreements that actually reply and answer in better ways.
Thank you. I think Professor McCrudden wants to respond.
Yeah, thank you very much, Mariana. That was absolutely fascinating. The problem seems to be that the problem is how to create a system that doesn't create disincentives for reaching agreement in the first place, right? And I think that's critical to what you've been saying. And the idea of the presumption of compliance, I think, is really very interesting here, because I think it is an attempt in part to deal with that problem, right? In other words, if the agreement can be unpicked subsequently, there's no incentive for the agreement to be reached in the first place, yeah? And if the more that likely it is that it's unpicked, the less likely there will be an agreement. So I'm intrigued as to how you would deal, for example, under the presumption of compliance in your treaty, your proposed treaty, with something like the Bosnia-Herzegovina problem, right? And you remember in Bosnia-Herzegovina, basically there was a consociational agreement which gave precedence to the main parties to the agreement, the three ethnic groups, yeah? And they were essentially ones that formed the upper house and the presidency. And the European Court of Human Rights basically held those to be not compliant with the European Convention on the grounds that it excluded those who self-defined as Jewish and Roma, yeah, because they were not included. Now, the basis for the agreement for the Bosnia-Herzegovina, for the Dayton Agreement, was absolutely clear. That agreement would not have been reached if those contested provisions had not been included. I think that's absolutely clear. So what do you do in terms of the presumption of compliance there? And how does it actually work then? Had that presumption of compliance been in practice operational at the time of the Bosnia-Herzegovina agreement? How do you envisage that actually working in practice?
Mariana?
Thank you so much. Well, I do think that this is exactly the point of the global consultation process, that we really want this treaty to be the best text that we can have, to be reality informed and shaped by best practices. So these kind of questions where we poke our brains and we ask ourselves, how can we make it better? What considerations need to be included in the drafting? Those are all very welcome, professors. Thank you very much. I would perhaps only say two things, because this is also a process that is under construction. But I would say first, I believe there is one element prior and one element after the peace agreement is reached. The element prior the peace agreement is reached is, how do I ensure that the peace agreement, the negotiators, actors, the parties have a more structured and accessible knowledge and technical support during the negotiations, so that we avoid having to think about those things after the peace accord has been reached, right? So this is one thing. And the peace agreement provides for the creation of an advisory support unit that will be structured. I mean, today, if negotiating parties are negotiating, they can reach out to different actors, they can reach out to negotiators around the world, but this will be an ad hoc exercise, and this will depend on the resources, on the access, on the network. What we want is to make this a structured, institutionalized, and organized, basically infrastructure that can be accessible more easily, faster, and have to spend less resources. So this would be the prior element. The element after, this is already too late. It has been done. I would say there is two dimensions. One is that when analyzing a peace agreement, courts, hopefully, because a human rights court will not necessarily start looking at international law of peace negotiation as a mandatory source of law. This will not happen. Even with international humanitarian law, it takes time for human rights courts to start looking at international humanitarian law as a source of law. But with time, it starts to be addressed, it starts to be looking as a body. It might become a body of law that is relevant for human rights courts and other courts, regional or international courts, to be looked at and understand what are the general principles, what are the aim, and enter in their decisions when looking at human rights. What was the aim? What were the values that needed to be balanced? And this is something I mentioned in my first remarks. But the second dimension is the presumption of conformity. I also touched upon this element, but as a presumption of conformity, it can be rebutted. So if the Conference of States identifies that the peace accord, the outcomes, its provisions with relation to atrocity crimes, so not everything, every single element, right? But in relation to atrocity crimes, is excessive or is unnecessary was unnecessary to achieve the aims of preventing and resolving the conflict, or that it really neglects the rights of the victims, then the Conference of State Parties may rebut those provisions within the accord, because it wouldn't be fulfilling, it wouldn't be complying with the general values and principles of what we're proposing, would be the principles of international law of peace negotiations.
Thank you.
Thanks very much, Mariana. I'm going to take a group of questions and then get the panel a chance to answer them. Lord Alderdice, a microphone coming round, I think, so that will enable Mariana to hear more clearly. So thank you. John.
Thank you very much indeed. You made the point, Richard, in your introduction at the start of the day, that external events can change things. And Dominic made the point that maybe the way the agreement was constructed 25 years ago does not necessarily apply to to some of the contexts now, and I think this is very important. It was a peace agreement, and the introduction of human rights elements to that, both legal and political, were largely for the purpose of addressing the concerns of the nationalist and Republican community. While in theory, they were there to protect everybody, in the context of the agreement, they were there to protect the concerns of the nationalist and Republican, quotes, minority community. It's very difficult to change constitutional arrangements such as a treaty of this kind, except in the context of some constitutional change. And I think that the most likely context for a change to a treaty that reflects the new situation, which is a post-peace process one. We are now in a political process rather than a peace process. We are not in violent political conflict, and I don't think we're going back to it. There may be a bit of huffing and puffing and a few burnt buses and a few people get shot on the loyalist side, but they only do disorganized crime. They don't do organized crime really very well. So the most likely context is actually in the expectation of, or the actuality of, a border poll which begins to change the constitutional position of Northern Ireland, in which case any political and legal protections would likely to have to be brought in respect of the loyalist and unionist community rather than the other way around. And the guarantor question becomes a very different question as well. It's not just British and Irish governments in the context of the European Union, the Americans and so on, because you're moving to a state which may not be a unitary state, but it will be interesting to think, what will it actually look like? I was talking some time ago to an old friend, a very old friend, who I got to know before the wall came down, and he remains very resentful as an East German that what happened was the absorption of East Germany into the West German constitution without any change of any structural or symbolic questions. I don't think that kind of absorption would be possible without trouble here. So I think that when we think about these questions, they're often talked about as though they were in a steady state context, where in actual fact, as Chris has pointed out, 2016 changed all of that, and subsequent years might change it all again in a very substantial way. I guess my thought would be to the thoughtful people that are around here, is it possible to begin a serious conversation about those kinds of things, which is not on a partisan basis, in order to explore them in the knowledge that many people in the unionist community, particularly political representatives, are not yet prepared to countenance or engage in that conversation.
John, thank you very much. Going to take a couple more questions if there are from the audience. No? Yep, there's a question here, and then another question from Martin. So we'll take those three. Thank you, and then we'll go to the panel.
Hi, Dara McGill, University of Oxford. No, fascinating presentation by everyone, and same for the first panel. Various questions, I guess. We're very much focusing on Northern Ireland, but I guess the idea is what are the lessons for Northern Ireland? So I guess talking more to Mariana and possibly Mark as well. Because I don't see the text. You mentioned in the flyers as an indicative text, but I didn't actually manage to find it anywhere on your website. So you're kind of coming here with a text saying, oh, this is something we've elaborated that we think is good, but it's hard for us to know actually what's in there because you haven't really told us, and I did come a bit late, so but I guess in 10 minutes you weren't able to set it all out. So various things to answer, that would be kind of something that would have been useful, so just a slight criticism there. But I guess my point is, I guess what Mariana was talking about at the end, about giving support to negotiators, that's one example, in a structured institutional way. I mean, I guess there's two questions on this. And if I was a cynic, I would suggest that this may be a way of kind of making sure international peace-building experts stay in job forever, and increasingly institutionalize those structures. And obviously there's a lot of critiques of that sort of top-down liberal peace-building. So, I mean, that's one kind of critique. The other thing would be, I guess, the moral hazard in the sense of when you say actors to the negotiations could access this support, which is advice, but also financial. How are actors in the negotiators defined and chosen? there's obviously then an element of moral hazard of groups getting involved in conflict in order to then access these financial benefits. So how would you stop that happening? So I guess that's kind of two questions.
Thank you very much. There's a question just along the row from you, from Martin. Thanks. Thanks, Martin.
Hi. Good afternoon, everyone. A question, I think, for Professor Topping, and it's like 25 years after the Good Friday Agreement, how does the nationalist community view the policing reforms? Is it seen as something that's a success and was a really good part of the Good Friday Agreement, or do we just not have the data to know?
Thank you. So a range of questions there, which in different ways relate to what all three panelists have said. I'm going to go in the reverse order that we had the session this morning. So I'm going to start with Mariana, then go to Chris, then go to John. So please, if panelists could answer the question or questions which seem to relate specifically to your own arguments, that would be great. Mariana.
Thank you very much for those very interesting and provocative questions. So first, with regards to the indicative text, I believe it is in the flyer of this event, which you received. It's in the promotional flyer, which is on the webpage. But if you haven't seen the flyer, we would be more than happy. We would be delighted to share the text with you, no problem. And any thoughts and comments are welcome, of course. With regards to the question in relation to the moral hazard, in fact, the idea for us is to reduce that moral hazard that already exists, because negotiations, they require resources. They require human resources, they require financial resources to determine the meetings, to conduct the meetings, to ensure the displacement from different parties to the place of the meeting, to conduct confidence building measures, etc., etc. So the idea is to stop to avoid having those support mechanisms in an ad hoc way, but rather to have them systematized and have them being more systematic in a way that they're more organized and structured and have, in fact, more control. How do we actually know the actors in a negotiation and who they're chosen, and how do we know where they invest the finances and the resource in? Well, in a negotiation, the parties choose who is the negotiator. And this is an issue that is different in every single process. It will also depend if it's a negotiation, if it's a mediation, if it's with the support of international community or not. But in any case, the resources that are provided are not for the aims or the political aims of each of the parties. Those resources are provided, and the contributions, the technical advisory support are provided for the sake of the negotiation process. They are provided for preventing and resolving the conflict in a peaceful way. And in that sense, for a country for a state to be able to access those incentives, because as you say, accessing those elements, accessing technical support, accessing financial support, accessing the possibility of having a presumption of conformity for a peace accord, those are incentives. Those are elements and tools that are attractive that could make negotiations faster. So those are incentives for states and for actors who might be engaged in a negotiation. So what we need to ensure is that this is not something that everybody could access just because one day they woke up and they wanted to ask for that. So what the peace treaty establishes or what it provides is that a state can refer a situation. So for a state party to be able to access all of those elements and tools, they need to refer a situation to the Conference of State Parties. And the situation would be a possible negotiation process. Only when referring a situation and only when that situation has been approved, then you can access all of these incentives and tools and opportunities that are provided within the peace treaty.
Thank you, Mariana. Chris McCrudden.
I'll just pick up one point that Lord Alderdice mentioned about the future. So I was very lucky to be involved in a project that University College London took up last year essentially, and produced quite a long report, which I know you know about, which tried to assess pretty systematically the kinds of issues in and around the modalities of a border poll, unification referendum, whatever you want to call it. And it turned out, of course, to be immensely complicated and requires a lot of choices. What we didn't do explicitly was to think about what might result from the border poll. So we looked at the modalities of it rather than the future. And of course, we did that because we were neither supporting nor opposing a border poll. We were simply looking at what you would need to do in order to operationalize it. It's true, I think, and worrying, particularly in the light of the 2016 referendum, that upsets happen in referenda. And the unexpected has to be planned for. One of the tragedies of 2016 was that there was no plan B. So it would be, I think, sensible, and I entirely agree with you, that these conversations need to happen. There is, of course, an initiative that University of Notre Dame and the Royal Irish Academy have taken to set up this body called ARENS, which is an attempt to provide a forum for this kind of conversation. And those of you who are interested in it, the Royal Irish Academy hosts a website which now has a very considerable number of academic papers on various aspects of precisely what you've been talking about. Not least a paper that David Kenny, Oren Doyle, and I did on some of the questions that you've just been discussing. The problem that you know as well as I do is that it's not that academics don't want to get involved. We're champing at the bit to be involved. The problem is that the unionist community will not engage. And I put it bluntly. So in the context of the UCL report, we systematically and at length attempted to engage explicitly with a whole range of unionist actors with very, very little success. There were some, and thank you to them who did, and they were very important in contributing to the report, but they were not political actors. And that's a problem. And I don't know how you deal with that, largely because there's clear incentive for unionists not to engage. And I entirely understand that. Why would you until you get a clear vote one way or the other? But by that time, in a sense, it's too late. So there is a real conundrum here, which I suspect others in the room have thought about this as well, how to bridge that gap, and I just don't know. So I threw the question back to you. Yes, there must be this kind of discussion. Yes, unionists have to be involved in this. It's about their future, potentially. But how to get them involved, I don't know.
Thank you. Before we just go to John now, on the ARENS work, next year, the Mitchell Institute, together with the Royal Irish Academy and Notre Dame, is going to have a series of public conversations about Britishness and Irishness, where in each case we're echoing what Professor McCrudden has said. It's not been straightforward, but we're going to try and get people who represent a variety of different views to be publicly involved, in the hope that it means that the conversation just doesn't have one side on it in public. And I think both hosting those, if we can pull them off, the idea is to have one in Belfast, one in Dublin, one in London, one in Washington. If we can pull those off, both having those conversations, but also the tone and nature of those conversations where people disagree without abuse, and where there's comity, if not agreement, I think would be a way of moving forward what you're describing. And I hope that will be one small contribution, but it is not straightforward. John? There was a
Yeah,
question specifically aimed at you.
On the measure, yeah, I mean, I think just on that measurement, I mean, we're not any different to any other jurisdiction in that we're very much held to the difficulty of how do you capture the granularity of views around policing, whether, you know, nationalist, Republican, you know, from BME communities as well. Now, while there's a broad raft of data, I remember going back, just a bit of a context, I remember going to, you know, into January 2007 to some of those initial meetings down at Clonard Monastery, top of the White Rock Road, about engagement with the police. And I think since then, and it's only my perception, there's very much been this sense that policing has always had to be seen to work. And I think in the midst of the Policing Board and the PCSPs and Department of Justice, we are missing some of those more difficult conversations and measurements. You know, communities in West Belfast will have a very different view to communities from different parts of Derry, and very different policing experience. So I think it's perhaps deliberate that there hasn't been a more calculated investment beyond the general what do nationalists and loyalists, you know, variously think about policing from the Policing Board. So I think that, as I've said before, that's a nettle to be grasped, but also I think as well measuring confidence in policing. You know, we are still, politics, unfortunately, is still, like every jurisdiction, but politics is very much a part of policing here, and the dynamics around that can change, you know, on the head of a pin. You know, when you look at some of the events, I think it was 2019, I ran an event here with the, you know, Chief Constable Simon Burns, very versed public experience, and he said he would, you know, take kids off paramilitaries. He appeared at Christmas Day with a high-powered rifle in Crossmaglen. There have been other incidents about the treatment of victims at the Sean Graham Memorial, paramilitary groups up in East Belfast, the arrest of journalists, Trevor Burney and Simon McCafferty. So when you take all those things together, I think, you know, it's difficult to get any definitive measure of what people think of policing and in what particular areas. And I think it's something we do actually need to invest more in a social scientific sense, because without that data, we are therefore left to the hostage of particular groups and particular views and particular political perspectives, perhaps without the backing of the harder data below that, and that only feeds the cycle of policing being bound up in politics, which very much Patton was about, taking the politics out of policing, and I think we're not in that place yet. So a very roundabout way of saying we have some data, but the accuracy, I think, is probably not particularly useful, and it's something we need to work towards as a criminologist. I would say that.
Thank you very much, John. We've had an excellent morning. A few words of thanks in bringing it to an end. Thank you very much to IFIT, to Mark and to Louisa and Mariana. It's great to see this partnership between Queen's and the Institute for Integrated Transitions flourishing. It's been a very vibrant set of discussions, and we look forward to the next steps. Thanks to all of you in the audience for your questions and for your attendance. It's been great to share this dialogue, both in her role in the Mitchell Institute and in the School of Law. Thanks to Professor Louise Mallender for the work she's done in leading the partnership from the Queen's side. For the logistical organisation, Institute colleagues Wendy Louise Smith, Louise Milligan and Brett Walker did a lot of work, so many thanks to them. But in closing today's session, for a brilliant set of insights, discussions, a raft of really important and original and very responsible ideas, please join me in thanking our panellists, John, Chris and Mariana.